Ah, the Homeowners Association. For some, it's the guardian of property values. For others, it's a source of some seriously frustrating disputes. And let me tell you, that relationship can get tense, and it can get tense fast. Today, we're going to dive headfirst into one of those real-life conflicts pulled straight from a legal decision.
So let me ask you this. What do you do when you're sure your HOA is breaking its own rules? You pay your dues, you follow all their regulations, but then you start to feel like the people in charge aren't playing by the same rulebook. Well, that's the exact situation two homeowners in Tempe, Arizona found themselves in, and they decided to do something about it.
All right, so let's meet the key players in our story. On one side, we've got homeowners Marinda Minch and Carlos Sanchez, and on the other, their HOA, Tempe Villages. The whole thing started because Miss Minch wanted a seat on the board of directors and was convinced she was being unfairly blocked.
This quote really gets to the heart of it, doesn't it? For Miss Minch, this wasn't just about some technical rule. It felt personal. She truly believed the board was going out of its way to exclude her, and that feeling adds this whole layer of human drama to what could have been a really dry legal fight.
Okay, so personal feelings are one thing, but for a legal case, you need a formal complaint. And theirs was built on one very specific rule. Article 4, Section 1 of the HOA's bylaws. They argued that the board was operating with only 6 members, which directly violated the governing documents that clearly state there must be 7. On the surface, it seems pretty black and white.
So to figure out who's right here, we've got to do exactly what the judge did. We have to go straight to the source. Let's crack open the community's official rulebook, the bylaws, and see what they actually say.
And there it is, right there in black and white. The bylaws state the board shall be managed by a board of 7 directors. For the homeowners, this was their smoking gun. I mean, if the board had fewer than 7, it had to be a violation, right? This one sentence became the entire foundation for their case. So here's how it all went down. A board member resigns back in August, which drops the board down to 6 people. Boom. That's when the supposed violation starts. Then, in October, there's an election, but afterwards, there are still only 6 members. The empty seat isn't actually filled until November, a full 3 months later. And from the homeowner's point of view, that 3-month gap was the whole problem. But this is where the story gets really complicated. As you probably know, when it comes to legal documents, one sentence almost never tells the whole story. The outcome of this entire fight actually comes down to the difference between 2 little procedures hidden away in the fine print of the very same article. So check this out. This is the crucial part. Not all board vacancies are created equal. According to the bylaws, when a director's term just naturally runs out, the new person is chosen by all the homeowners. That's an election. But if a director resigns or is removed, their replacement gets picked directly by the other board members. That's an appointment. 2 very different situations with 2 totally different solutions. And that explains everything. It's why the board still had only 6 members after the October vote. That election was only for the 2 seats whose terms were naturally expiring. It had absolutely nothing to do with the seat left empty by the resignation back in August. Filling that seat was the board's job, and they were supposed to handle it through an appointment on their own time.
And the record shows that's exactly what the board did. At their meeting in November, they finally dealt with that vacancy. A motion was made to appoint Marinda Minch, but it didn't pass. Then, a second motion to appoint someone else, Cristiana Piraggi, did pass. The board had followed the appointment procedure from their own rulebook to the letter. Okay, so all of this lands on the desk of an administrative law judge. They had to weigh all the evidence, the owner's claim, which was all about Section 1, and the HOA's defense, which was based on Sections 2 and 3.
Now, in a civil case like this one, the homeowners had what's called the burden of proof. That means they had to convince the judge that it was more likely than not that the HOA broke the rules. It's not like a criminal trial. There's no beyond a reasonable doubt. You just have to tip the scales of probability even slightly in your favor. And they couldn't do it. The judge dismissed their petition. The ruling was crystal clear. The homeowners just didn't meet their burden of proof. The evidence simply didn't back up their claim that a violation had ever happened.
And honestly, this quote from the judge's decision sums up the entire case perfectly. You can't just cherry pick one sentence, the part about needing 7 directors, and just ignore the other sections that explain how you're supposed to maintain those 7 directors in different situations. Reading the whole document, understanding the context, that was everything.
So, what's the big lesson we can all take away from this? Well, first, a single rule, just like a news headline, can be really misleading. You've got to read the whole story. Second, it is absolutely crucial to understand that different problems often require completely different solutions. And finally, in any dispute like this, that fine print isn't just a suggestion, it's the whole ballgame.
And that leaves us with one final thought, and this one's for you. Whether you live in an HOA, a condo association, or even belong to a local club, there are rules that say how it's supposed to run. This whole case is a powerful reminder that really understanding those rules, all of them, is the most important step for anyone who wants to be involved. So, do you know yours?